post office witnesses working across the inquiry's relevant period. Horizon is a multifunctional system encompassing points of sale services and over 100 additional services, including, amongst other things, financial services, government services and lottery purchases. It is a large, bespoke and highly complex system developed by Fujitsu in conjunction with Post Office for use in post office branches. It interfaces with numerous different post office and third-party systems. Initially, Horizon was rolled out between 1999 and 2001 and remains in use in post office branches across the United Kingdom today. Horizon was and remains but one part of the post office's IT infrastructure, supported not only by Fujitsu, but various other third-party suppliers. Both the inherent complexity of the system and the obvious potential for bugs, errors and defects necessitated that processes governing the identification, communication, escalation and resolution of bugs, errors and defects were put in place at the start and remain in place between Post Office and Fujitsu. Fujitsu has frankly accepted that whilst these formal and informal information sharing systems were generally effective in practice, they were not uniformly so. The evidence heard over the course of the inquiry nonetheless compels the conclusion that, in general, Fujitsu routinely and continually shared information concerning the existence of the impact of bugs, errors and defects with Post Office. It therefore follows the contemporaneous knowledge of bugs, errors and defects within Post Office went well beyond acknowledgement of the mere theoretical possibility of bugs, errors and defects. Post Office has been aware for at least 25 years of the potential for and existence of bugs, errors and defects in the Horizon IT system, as well as the potential for those which are unknown and unresolved to exist. Post Office was also aware in 1999 of the potential for bugs, errors and defects to impact upon the integrity of branch accounts. By way of illustration, in the annex to Fujitsu's final written closing submissions in this inquiry, Fujitsu has identified at least 70 individuals within Post Office and Royal Mail in relation to whom the inquiry has received unequivocal evidence of their knowledge of bugs, errors and defects. This includes members of the Post Office board, senior executives, in-house lawyers, as well as individuals working in Post Office's security and investigations teams. That knowledge spans the entirety of the period being examined by the inquiry. The sheer number of Post Office and Royal Mail personnel who were aware of the existence of bugs, errors and defects is potentially relevant to the inquiry's work in another way. A number of witnesses before the inquiry could either not recall with accuracy whether or in what circumstances they were made aware of the existence of bugs, errors or defects, or positively denied such knowledge in circumstances which might be thought to be surprising. In assessing that evidence, the inquiry will be entitled to conclude that, while of course knowledge held by one person cannot unfairly be attributed to another, and while Post Office's corporate knowledge cannot be aggregated for all purposes, the inquiry is entitled to infer from the breadth and depth of awareness of bugs, errors and defects within Post Office that it is likely that key institutional decision makers did, in fact, have such knowledge. The question of why this expansive institutional knowledge was not appropriately considered by Post Office or its legal representatives in the context of proceedings against Subpostmasters is a significant one, and a matter that will no doubt be the subject of careful deliberation by this inquiry. Further, in its opening statement to the inquiry, Fujitsu accepted that Fujitsu staff had and continues to have the ability to remotely access Horizon. That access was and is possible in multiple ways, via various ingress access types, from the time of the initial rollout until now, including in both Legacy Horizon and HNGX. Fujitsu has reiterated this position throughout the inquiry. Remote access was and remains a necessary part of the suite of support tools available to manage the live operation of the Horizon IT system, including the attempts to rectify bugs, errors and defects. Indeed, support staff from Fujitsu state in evidence that they could have not done their jobs or operated Horizon without it. In its opening statement to this inquiry, Fujitsu submitted, I'm sure you will recall, sir, that Post Office had been aware from an early stage of Fujitsu's ability to remotely access the Horizon system. That submission has been borne out by the evidence given to the inquiry and was belatedly accepted by Post Office in its final closing submissions. But whilst abuse of remote access privileges by a malign actor cannot positively be excluded on the evidence, there is no evidence for it and no reason to suppose it occurred. Most importantly, there's no evidence to support the suggestion that remote access privileges were used for any purpose other than to provide necessary technical support to Post Office branches. In other words, there's no evidence to support any suggestion of the malign use of remote access capabilities. It's regrettable that in its written closing submissions, Post Office sought to obfuscate its proper share of responsibility for the events which are the subject of this inquiry by seeking wrongly to deflect blame to Fujitsu and other third parties. Post Office has sought to characterise itself as the subordinate partner in the relationship with Fujitsu and as operationally and technically dependent on Fujitsu. Perhaps tellingly, sir, you might observe that these submissions, as paragraph 101 in the Post Office written closing submissions, are unsupported by any reference to the evidence before this inquiry. That's unsurprising, because the submissions bear no resemblance to that evidence. So you'll be aware that Post Office previously has sought to shirk liability by deflecting responsibility for its share of organisational failings in its submissions to the Court of Appeal in March 2021 in the case of Hamilton and the Post Office. The Court of Appeal rejected that attempt, holding that Pol knew that there were serious issues about the reliability of Horizon. If Pol needed further information, it could have obtained it from Fujitsu. That was a finding that was omitted by the Post Office when quoting that same section of the judgment in paragraph 10 of its written closing submissions. The evidential basis for that conclusion is even stronger on the evidence before this inquiry, and we would invite you to adopt the same course as the Court of Appeal. To the extent that it is ever appropriate to describe one party to an extensive and sophisticated commercial contractual arrangement like the Horizon contract as subordinate, is clear beyond argument that the Post Office is not such a party. Post Office has been and remain very much in the driving seat of that contractual relationship. As we saw in phases 2 and 3, it was Post Office who specified the technical requirements by which the Horizon IT system was developed and by which it has been changed over time. As we saw in phase 4, it was Post Office who determined the nature and extent of the prosecution support which Fujitsu was required to provide, including, by way of example, stipulating the form by which the ARQ requests were made. Even in phase 7, we see the arrangements for the end of service life of Horizon IT system continue to be sensitive to Post Office's commercial needs, despite Fujitsu's serious reservations. More generally, the evidence for Post Office dependency on Fujitsu is conspicuously thin. Post Office has at all material times had its own IT function. It's employed a number of IT specialists, including highly experienced individuals such as Leslie Sewell, who held positions of management and oversight concerning all of Post Office's IT functions, including the Horizon IT system. As would be expected, the business-as-usual operation of the Horizon IT system entails the sharing of vast quantities of information about the system, including, again entirely unsurprisingly, about technical issues and bugs, errors and defects. In the annex to our closing submissions, Fujitsu has summarised some of those key means of information sharing. Post Office has also had at significant times throughout the life of Horizon its own testing teams, tasking with ensuring the quality of certain releases of Horizon. Post Office relies upon what it describes as repeated assurances from Fujitsu that Horizon was reliable. It does not cite even a single example of such an assurance being given. To the extent that certain Post Office witnesses similarly suggested that they'd been provided with assurances as to the integrity of the Horizon IT system by Fujitsu, there was a complete lack of evidence to support those claims. Indeed, as Fujitsu pointed out in its Phase 3 closing submissions, those claims were either entirely vague and, confusingly, often made by individuals with no direct engagement with Fujitsu at all. A better view of the evidence, sir, as Fujitsu submitted at the end of Phase 3, is that a message from the top within Post Office consistently emphasised, without evidence, the robustness of the system. Having said that, sir, to be absolutely clear, despite the observations that I've just made, and also will continue to make about Post Office, I repeat, Fujitsu stands by all the matters it has accepted in its written closing statements. Post Office investigations and prosecutions did not begin with the introduction of the Horizon IT system. Post Office had an established, active investigation and prosecution function in place prior to the national rollout of the Horizon IT system in 2000. The available evidence demonstrates a significant increase in investigative and prosecutorial activity during the period of 1992 to 1998. This initial increase in investigative and prosecutorial activity occurred following the introduction of an in-house accounting system called Capture into Post Office branches in 1992 and predates the rollout of the Horizon IT system. The conduct of criminal prosecutions on behalf of Post Office fell considerably short of the important duties which apply to a private prosecutor. Hundreds of sub-postmasters were wrongfully prosecuted. Indeed, the evidence now available to the inquiry suggests that the failings in the conduct of Post Office prosecutors were considerably more fundamental than even those acknowledged in the Court of Appeal in the Hamilton and Post Office case. In Phase 4 of the written closing submissions, Fujitsu made detailed submissions as to the wide range of serious deficiencies which undermine the integrity of Post Office prosecutions. I do not repeat those submissions today. Fujitsu nevertheless acknowledges that the codified agreement between Fujitsu and Post Office contained novel propositions, contractually obliging Fujitsu to provide support to Post Office in respect of prosecutions. That work was atypical for an IT service provider such as Fujitsu and was outside the normal work of Fujitsu technical staff. It is a matter of profound regret to Fujitsu that it ever provided services to support Post Office proceedings against sub-postmasters. Fujitsu was never cited on the full scale of Post Office's prosecutorial conduct and misconduct, and so that's plain from the fact that it did not provide evidence in all the cases. Nonetheless, Fujitsu accepts that it was inappropriately deferential to Post Office as its client and its senior management were insufficiently interventionist in their management and oversight of the Post Office account. This led to a failure to properly challenge or scrutinise the appropriateness of requests made by Post Office and resulted in Fujitsu providing a service, prosecution support, which fell short of its own corporate values. In light of this, Fujitsu recognises that it failed properly to support those of its employees who engaged directly with Post Office and its lawyers in respect of prosecution support. This is particularly so for those who engaged in the provision of documentary and witness evidence in relation to Post Office prosecutions and civil actions, with technical employees often left to engage directly with Post Office internal and external lawyers, rather than having appropriate mechanisms by which to monitor and support those employees. In his written closing submissions, Gareth Jenkins notes particular failings of Fujitsu in its management and oversight of the prosecution support which he came to be required to provide. So I can make it clear that Fujitsu accepts those failings. In the course of Phase 7, the inquiry explored issues regarding ongoing and future criminal investigations and prosecutions involving Post Office. Post Office's renewed interest in criminal investigation and prosecutions appears to be driven by a perceived need within the Post Office for a deterrent and to recover apparent shortfalls. Despite the startling evidence heard during Phase 4 of the inquiry in relation to the conduct of Post Office investigators and lawyers in the context of proceedings against Subpostmasters, as recently as July 2022, Post Office boasted in internal documents that its investigations unit, the first recognised investigations unit in the world, it claims, has an unblemished reputation. A significant focus of that evidence, and regrettably a source of some confusion in the Phase 7 evidence, was the nature of assistance, if any, which Fujitsu had provided or was willing to provide in support of such investigations. Moreover, Post Office's engagement with ongoing law enforcement investigations raises real questions as to the extent to which lessons have been learned regarding the matters which have been the subject of this inquiry. Fujitsu has set out the position in detail in its final written closings to ensure that that concern is fully aired. But in summary, it's as follows. Between February and July of 2024, Fujitsu was contacted by 4 police forces in relation to 4 cases. This apparent flurry of criminal investigations, each of which appeared to have been referred to the relevant police forces by Post Office, caused Paul Patterson and his colleagues at Fujitsu such concern that Mr. Patterson felt it necessary to escalate the matter to Nick Reed as the CEO of Post Office. Mr. Patterson was particularly aggrieved by some of the language used by Post Office staff in context of these criminal investigations, and the apparent inference by those members of staff in what appeared to be matters relevant to the police forces. Fujitsu does not know why it has not been contacted by the other police forces in connection with other investigations. It's been suggested by some core participants that this correspondence and Fujitsu's correspondence with some police forces may reflect tactical positioning for the purposes of the inquiry. So I can be completely clear on that front. Inevitably, Fujitsu's attitude to the use of data derived from the Horizon IT system in criminal investigations and prosecutions has been informed by the shocking evidence heard by this inquiry. Fujitsu is astute to ensure that it does not repeat the mistakes of the past, and to ensure that it does not lend its assistance to Post Office in repeating those mistakes. Moreover, far from that tactical positioning, Fujitsu's position regarding ongoing and future criminal prosecutions has remained consistent since its declared position on the 16th of June 2020 in its letter to the Bays Select Committee that it will provide information to the police and other appropriate judicial authorities, but not to Post Office-led prosecutions. To reiterate, Fujitsu has offered and will continue to offer full cooperation to any police force conducting an investigation into potential criminal wrongdoing in connection with Post Office branches. Fujitsu will cooperate with police forces in the preparation of factual witness statements to address matters relevant to those criminal investigations. Fujitsu is, however, determined not to repeat mistakes of the past, which have been so starkly revealed by this inquiry. In this context, Fujitsu is acutely aware that it is not in a position to offer independent expert opinion from any employee regarding the operation of the Horizon IT system. Fujitsu is also aware of the need to make full and appropriate disclosure regarding its knowledge of bugs, errors and defects in the Horizon IT system, including the potential for unknown, undiscovered and unresolved bugs, errors and defects affecting the live system, particularly as it ages without further investment and the existence of remote access. In addition, Fujitsu is also mindful that a consistent theme of the evidence before the inquiry was the error in producing evidence for criminal proceedings from the Horizon IT system data, of focusing overly narrowly on whether there is a specific evidence of a bug or error or defect affecting a particular branch at a particular time, as compared to the potential for bugs, errors and defects, including the unknown ones, within the network more broadly, and is eager that police forces do not repeat the same error. In other words, by asking Fujitsu to provide evidence limited to a particular branch. Relatedly, Fujitsu has become concerned by some of the correspondence it's reviewed between the Post Office and the relevant police forces. In particular, the letter sent by Post Office to the Lancashire Constabulary on the 25th of April of this year, and then provided by the Lancashire Constabulary to Fujitsu some 3 months later, on the 24th of July 2024, is significant in a number of material respects. Fujitsu sets out the severe deficiencies of the content of that letter in its written closing submissions. However, in the context of the apparent resurrection of Post Office's criminal enforcement activity and the quick dismissal of Fujitsu's concern by both Mr. Reid and Owen Woodley, the content of that letter seemed to Fujitsu to be so egregious that Mr. Patterson decided to write to Post Office 2 days later to cease any further correspondence on the matter. There is no merit whatsoever in the suggestion, principally made by John Bartlett, that Fujitsu has been obstructive or uncooperative with police investigations. Fujitsu is surprised by that suggestion, which is plainly at odds with the evidence. Further, given the significant miscarriage of justice with which this inquiry is concerned, a cautious approach in these cases is both reasonable and appropriate. In its opening statement to the inquiry on the 4th of October of 2022, Post Office submitted that it embarked on an ambitious and accelerated large-scale effort to retire Horizon by 2025 and replace it with a new system. Over the course of Phase 7, the inquiry has received evidence concerning MBIT and the progress that has been made towards replacing the Horizon IT system. Increasingly, it's become clear that the MBIT programme has experienced prolonged delays and technical challenges. It's also become clear that Post Office is no closer to replacing the Horizon IT system than it was at the beginning of this inquiry when it made its opening statement. In the interim, and something of concern, insufficient investment has been made in the Horizon IT system. The Horizon IT system is on an end-of-service life IT infrastructure, and due to this status and its age, there's an increasing risk of the existing Horizon IT system infrastructure failing. That could inversely impact the delivery of services to the public. Since 2020, Fujitsu has consistently communicated its concerns to Post Office in relation to supporting end-of-life service infrastructure, and that it wishes to exit the Horizon contract. Sir, as I've said, the core of this inquiry are the sub-postmasters and their families who were so profoundly and tragically affected by the appalling miscarriages of justice. Fujitsu reiterates its sincere apology to the sub-postmasters, employees and their families. The inquiry has conducted a thorough and searching investigation. The work of the inquiry has revealed the technical, human and organisational failings which contributed to the suffering of sub-postmasters and their family. Fujitsu accepts its share of those failings and has set out in writing the detailed matters which it does accept. That said, the relative brevity of this oral closing and the shorter than some written closing should not be taken as an acquiescence to all the criticisms levelled at Fujitsu, particularly some of those I've touched on by the Post Office. As already I have submitted, prior to the commencement of this inquiry, the appalling miscarriages of justice that have now been laid bare by the evidence received by this inquiry were framed as resulting primarily or exclusively from IT issues. That as evidence has demonstrated that these miscarriages of justice were not caused by technological failures exclusively or even primarily, but are instead the product of serious human and organisational failures in conduct, ethics, governance and culture. Fujitsu hopes that having supported the inquiry through its work, it has gone some way to demonstrating its commitment to learning lessons from the inquiry process and, most importantly, to ensuring that the mistakes of the past are never repeated. Thank you, sir.
Thank you, Mr. Whittam. So it's just about 12 o'clock. Ms. Dobbin, would you like to make your submissions in one go? Answer, I suspect, yes. So would you like to have an early lunch or make them now?
Sir, I would like to make them in one go, if that's okay.
And would you prefer to make them now, or shall we take an early lunch?
Well, so perhaps if we took an early lunch, if that was all right.
Yep.
Thank you.
So we'll begin again at, well, 1 o'clock. Okay. I think we're all set, Ms. Dobbin.
Thank you. Sir, Gareth Jenkins was interviewed by the police in 2021, just after this inquiry had started in its current incarnation, before the vast disclosure that it has afforded. He told the police in that interview that he had not been instructed as an expert by Post Office in the cases in which he had been a witness. That might have been surprising for the police investigators to hear. That might have been confusing for them, given the Clark advice was premised upon Mr. Jenkins' failures of disclosure as an expert witness, given the Horizon Issues judgment, and given the Court of Appeal judgments and their focus on the Clark advice. Confusing, given that Post Office's position before the Court of Appeal was that the fact that Mr. Jenkins had given evidence in a case meant that Post Office did not disclose the full and accurate position regarding the reliability of Horizon. See paragraph 207 of the Hamilton judgment. In other words, that the focus was squarely on Mr. Jenkins and his failures of disclosure as an expert witness. It was no less shocking to Mr. Jenkins, who retired in 2015, to have found himself the focus of so many criticisms and indeed singled out in the Horizon Issues judgment, and then to find himself blamed by Post Office before the Court of Appeal for a number of miscarriages of justice. These were criticisms made of him that he had no opportunity to address. He had no chance to explain to Mr. Justice Fraser, as then, that he was not correct in the way that he attributed to Mr. Jenkins blame for inaccuracies in the evidence of some witnesses. He wasn't able to explain that there had been a large number of people who had commented upon the witness statements. Mr. Jenkins wasn't able to explain the role that he had within that team. He wasn't able to explain that when it came to correcting the position about the use of remote access, that it was he, Mr. Jenkins, who did so, despite the fact that there were members of the SSC who were involved in the civil litigation. Mr. Jenkins wasn't able to explain where he had obtained the information about the Calendar Square bug from. He wasn't able to explain that its existence had been disclosed in Mrs. Misra's trial, contrary to the letter that Mr. Justice Fraser sent to the DPP. He wasn't able to explain the background to his communications with Miss Rose. There were many things that he was not able to explain to Mr. Justice Fraser, and which would have put a very different complexion on matters. These are the things that show him not to have been the ventriloquist that my learned friend, Mr. Henry King's counsel, accuses him of being, and which are set out in detail in his fourth witness statement. Mr. Jenkins had no opportunity to tell the Court of Appeal that he had not been instructed as an expert in Post Office cases and had provided information to Post Office that he was now being criticised for not having disclosed. He had no opportunity to tell the Court of Appeal that, in fact, Post Office knew a lot about the bugs, which it was accusing him of having not disclosed. There was no one in the Court of Appeal able to point out the hypocrisy and the inaccuracy of Post Office's position, that the issue was not that of the single expert who had failed in his duties of disclosure, but that Post Office as an organisation and individual investigators and lawyers had no concept of basic laws and ethics of prosecuting, that this incompetence extended to their use of Mr. Jenkins. Mr. Jenkins, in fact, had no idea until 2021 of the existence of the Clark advice. He had been misled in 2013 as to why Post Office no longer needed assistance. He had been asked by Post Office to assist in the civil litigation. No one saw fit to tell Mr. Jenkins why he wasn't being called as a witness. No one told him the reason you're not being called as a witness, Mr. Jenkins, is that Post Office has blamed you in a series of cases for failing to disclose bugs. You will draw your own conclusions, sir, as to what that says about the lawyers involved. Mr. Jenkins didn't have the opportunity to speak to Mr. Clark about his advice. Mr. Jenkins didn't have the chance to tell Mr. Clark that his statement was a response to 4 questions that Mr. Singh had asked him to answer. He did not have the opportunity to tell Mr. Clark that he had not been instructed as an expert when he gave this statement. He wasn't able to explain that in cases in which that statement had been used, he had explained to lawyers what the ARQ data might show, and that lawyers from Cartwright King had said no to obtaining that data. So what this inquiry has established are 4 essential truths which neither Lord Justice Fraser nor the Court of Appeal were aware. First, the Post Office was well aware of the bugs and issues that it was accusing Mr. Jenkins or Fujitsu of not having disclosed. Second, that Mr. Jenkins was not instructed as an expert in a single case in which he gave evidence. Third, that this failure to instruct Mr. Jenkins as an expert was apparent to Cartwright King and Post Office from the point of the Clark advice in 2013. Fourth, that Post Office as an organisation and individual investigators and prosecutors did not know or did not apply basic laws and rules and guidance which apply to prosecuting. Returning to the critical point about what Mr. Jenkins told the police in 2021, that he hadn't been instructed as an expert in any case. In summary, that Post Office had put Mr. Jenkins forward as an expert in criminal cases, had sought out his opinions and then to rely on them, but had never actually instructed him as an expert witness, appeared extraordinary, and giving rise to the question, how could that possibly have happened? So this inquiry, having disclosed in excess of 270,000 documents, confirms not just the truth of what Mr. Jenkins told the police, but the answer to the question how it happened that he wasn't instructed as an expert. There are 2 fundamental reasons. First, quite simply because investigators and lawyers did not know or ignored the law that they ought to have been applying. The evidence before this inquiry demonstrates a profoundly more disturbing picture of prosecutorial incompetence than could have been imagined at its outset. Disturbing for its lack of regard for very basic law and ethics which govern prosecuting. Disturbing because it was being done by a private prosecutor cloistered from the usual forms of scrutiny that apply to a public prosecutor, and given all of the vested interests at stake. The second reason why it happened was that prosecuting lawyers didn't address the capacity in which they were relying upon Mr. Jenkins to give evidence. They didn't distinguish between Mr. Jenkins as a horizon technical expert and Mr. Jenkins as an expert witness as a matter of law. The fact alone that every single of Mr. Jenkins' statements was an ordinary Section 9 witness statement that contained none of the content necessary to render it admissible as expert evidence demonstrates this. And ultimately, Mr. Warwick Tatford's evidence confirmed it and demonstrated in human terms how it happened. Throughout the prosecution of Mrs. Misra, there was, in his words, a muddle as to the capacity in which Mr. Jenkins was being relied on. So, given that Mr. Jenkins gave oral evidence in Mrs. Misra's case, without being taken through any of the steps to establish that he was giving evidence as an expert, that he was not taken through expert duties, that no steps were taken in his evidence to rectify that none of his statements complied with the requirements of expert evidence, that he wasn't asked any questions as to why his statements didn't comply with the requirements of expert evidence, that no one asked if he had prepared his evidence compliantly with expert duties, that this makes clear that the muddle on the part of prosecutors as to what sort of witness he was continued into his giving oral evidence. So I want to be clear at the outset of this submission that it focuses in part upon the failure of Post Office to instruct Mr. Jenkins as an expert, because the key allegation that he has always faced is that as an expert witness, he breached expert duties by not providing disclosure of bugs, errors, and defects. The fact that Mr. Jenkins was not instructed as an expert is critically important, because the evidence that he gave and how he provided it was a product of the approach which Post Office took to him, and specifically the communications which Post Office had with him as to what his evidence was to address. The inquiry's evidence has proved the negative, that he wasn't instructed as an expert in any case, and so the allegations against him have shifted to generalised allegations and insinuation that he lied or was party to presenting the veneer of Horizon as though it was infallible. There are two fundamental obstacles to this characterisation of Mr. Jenkins. First, that he provided the sort of information that he is accused of withholding, notwithstanding the way he was communicated with and used by prosecutors. Indeed, Mr. Jenkins openly adverted to information which it has been submitted in this inquiry there was a campaign to keep secret. For example, Mr. Jenkins told Professor McLachlan and the prosecution in Mrs. Misra's case about the known error log and told them that there were 200,000 faults in the live and test system on Horizon. This material was known to the defence because Mr. Jenkins told them. In his 2012 statement in the Wiley case, Mr. Jenkins confirmed Fujitsu's ability to use remote access. This was the first public confirmation of the position. This statement was regarded in 2015 by Post Office and Mr. Parsons of Womblebond Dickinson as going significantly beyond that which Post Office had ever confirmed about remote access. Mr. Parsons described that it would be a red rag to second sight. The second obstacle is that Mr. Jenkins never sought to convey Horizon as infallible. Rather, for example, he advocated an approach of obtaining the data for a given branch in order to see what may have happened. The assessment of Mr. Jenkins does not lie in generalisations. It lies in the reconstruction of how he was approached by Post Office lawyers, what evidence he was asked to provide, and how he responded. It lies in the assessment of the information he did provide to Post Office prosecutors and how they treated it, and why some of that information never came to be recorded on any disclosure schedule. Sir, he did not lie. He sought to answer the questions that Post Office lawyers asked him to address. He was demonstrably not part of any approach which sought to perpetuate Horizon as infallible. Sir, my learned friends yesterday focused on events after the Clark advice and the allegations of cover-up about it. There is a very obvious irony that it was Mr. Jenkins' openness with Second Sight and his provision of information about bugs to Second Sight that meant he became subject to allegations of non-disclosure. Mr. Henderson of Second Sight contemporaneously described Mr. Jenkins as having been straight as a die. When he was asked about this observation in his evidence, Mr. Henderson explained, "He wasn't being evasive. He was happy to help. He was answering my questions. He provided promptly with follow-up material that I requested. I mean, there was no hesitation in his willingness to answer our questions and to provide assistance. So he was willing to discuss remote access when Post Office was not. Yes." Mr. Henderson also explained, "I saw him as a technical expert and that he approached things from a technology perspective almost exclusively. He didn't strike me as a company person or feeling that he had to stick to a particular party line in terms of supporting Fujitsu. He was dealing with things at a technical level as a technical expert, and I find that rather refreshing. Was he taking the defensive position that Post Office was, which you describe in your statement? No." So these points are not just important to demonstrate that Mr. Jenkins had provided Post Office with information relevant to the operation of Horizon, but that there was clearly no design, no strategy on his part to withhold information. To the contrary, that he provided guilelessly in the course of criminal cases the sort of information that Post Office was claiming to have been unaware of. Indeed, sir, it might have been thought that Mr. Jenkins' willingness to provide information to Second Sight was another good reason to speak to him in 2013 to investigate the circumstances in which he had given evidence. So we respectfully agree with those representing the Hudgell and the Hodge Jones Allen core participants that there ought to have been an examination in 2013 of the circumstances in which Post Office had used Mr. Jenkins. For, had that happened, it would have demonstrated Cartwright King's involvement in obtaining the very witness statements which Mr. Clark was considering in his advice, an involvement which Mr. Atkinson King's counsel has been so critical of in this inquiry. It would have demonstrated Cartwright King's failure to instruct Mr. Jenkins as an expert. And perhaps, sir, most important of all, it may have revealed or begun to reveal the sorts of prosecutorial incompetence that Post Office's use of Mr. Jenkins demonstrates, and which has only been revealed here in this inquiry. About this inquiry, sir, I pause at this point to reflect on Mr. Maloney King's counsel's observation about the witnesses who have come before this inquiry and been amnesiac until they've remembered things that have been helpful to them. So Mr. Jenkins wasn't that sort of witness. He came and gave evidence before you for 4 days. He answered all questions despite the position that he was in, and he demonstrated himself to be incapable of putting a self-serving gloss upon his evidence. He stands in stark contrast to many of those who have given evidence before you. So before addressing some specifics, I wanted to make 3 observations, if I may. 3 overarching observations. The first is this, that Mr. Jenkins was an engineer in a legal world. Mr. Jenkins was a computer engineer to the core. He had been one for over 30 years before being asked by Mr. Pinder of the Fujitsu legal support team to help in Mr. Thomas's case. He had no legal training whatsoever, no training about being an expert witness. He was involved in designing parts of Horizon and as part of his role in fourth line support in identifying the root causes of problems which arose in Horizon. He had been schooled by these decades of computer engineering to think in terms of system and logic and problem solving. As Mr. Henderson said, this was a sort of exclusively technological perspective. He was at a very considerable, if not total, remove from the type of expert usually called in criminal proceedings. It's not simply that he wasn't a professional expert witness, that he wasn't giving evidence in a recognised field of expertise, that he wasn't a member of an expert institute, that he wasn't involved in research or bore any of the hallmarks of a professional expert, but that he was being called upon to give an opinion on the very computer system he had spent so many years working on and continued to do so. Some of my learned friends' submissions proceed as though Mr. Jenkins was appearing as a witness on a near consistent basis. For example, my learned friends Mr. Maloney and Miss Patrick's written submissions suggest that time and time again, Mr. Jenkins was reading expert reports or meeting with experts or signing joint reports. Mr. Jenkins was at all times a full-time and busy engineer on Horizon. His involvement in cases was sporadic, and the nature of that involvement varied greatly. As the inquiry has seen, his involvement in Mr. Thomas's case in 2006 was limited to the issue of zero transactions. He didn't encounter a defence expert until his involvement in Mrs. Misra's case in 2010, which I'll come back to in detail. But this was the high point of his involvement in any of Post Office's criminal cases, and the only one in which he gave evidence. In that case, Mr. Jenkins and Professor McLachlan made a short joint statement, but conspicuously it did not have an expert declaration on it. Mr. Jenkins didn't agree a document again with a defence expert until 2013 in Mr. Ishak's case. And again here it's conspicuous that this document was Miss Ibbotson's report, with some of Mr. Jenkins' narrative added. The expert declaration was Miss Abbotson's alone. Indeed, the document wasn't signed by Mr. Jenkins. After Mrs. Misra's case, Mr. Jenkins only made a statement in one other case until the 2012 generic statement. The nature of the generic statement and Mr. Jenkins' subsequent involvement in the 2012 and 2013 cases was very different again to Mrs. Misra's case. So, sir, quite simply, the broad language of time and time again is not borne out by consideration of the detail. Rather, Mr. Jenkins was an engineer navigating from time to time a legal world he was unequipped and untrained for, which alone would be concerning before considering Post Office's purported use of him as an expert. He was entitled to trust the lawyers that he was dealing with and to trust that they were competent and acting lawfully. Indeed, people like Mr. Singh, who had the Post Office endorsement of being a senior lawyer or the head of criminal law. Mr. Jenkins didn't have the framework to know that what any of these lawyers were saying or doing was wrong or to challenge them. And it's important to emphasise, sir, that in Mr. Jenkins' case, every single lawyer and investigator with whom he dealt was incompetent or acted in ways that was inconsistent with their duties. So you need only think of the case studies before you to see this. Mr. Ward and Miss Matthews in Mr. Thomas's case, Mr. Singh in Mrs. Misra's case, Mr. Singh in relation to the generic statement, and then Mr. Bowyer, Mr. Smith and Mr. Bolts, and the very junior paralegal, Miss Panter, in the 2012 and 2013 cases. As Mr. Smith of Cartwright King observed, quite why Cartwright King thought it was appropriate to take on prosecution work, really with hindsight I have no idea, because we certainly didn't have the training for it, and I was unaware of the duties on a prosecutor in relation to the instruction of an expert witness. So the second overarching point, Mr. Jenkins was never instructed as an expert. So Mr. Bear, King's Counsel, asked Mr. Atkinson, King's Counsel, this: if it's right that the Post Office or its agents, Cartwright King later, did not provide Mr. Jenkins with written instructions that conform to the requirements we've mentioned, didn't provide Mr. Jenkins with instructions as to his duties as an expert, and none of the statements included the necessary elements that we've identified, would you be able to draw an overall conclusion that there was a fundamental failure to instruct Mr. Jenkins as an expert? To which Mr. Atkinson replied, clearly that's ultimately a conclusion for others than me, but certainly it's not a conclusion from which I would dissent at all. with the limitation you've just included, was it a persistent failure? Yes. So the evidence overwhelmingly demonstrates that Post Office did not provide Mr. Jenkins with written instructions that conformed to the requirements of instructions for expert evidence. Written communications with him didn't even approximate expert instructions. The evidence goes much further. The failures were not simply those of omission, they were failures of commission. Lawyers misstated to Mr. Jenkins what his role was or what the evidence was he was to give. Post Office didn't provide Mr. Jenkins with instructions as to his duties as an expert. There isn't a single document before this inquiry in which Post Office provided Mr. Jenkins with these instructions. Every single lawyer who has appeared before you conceded that they had instructed Mr. Jenkins as to expert duties. And so I include Mr. Warwick Tatford in that for reasons which I will return to. So none of the statements included the necessary inclusions to make it admissible as expert evidence. So the third overarching point, the fact that Mr. Jenkins was never instructed as an expert cannot be treated as irrelevant. So this third point can be made shortly. It is impossible to treat as irrelevant that Mr. Jenkins was not instructed as an expert. In other words, to take an approach to Mr. Jenkins which accepts that he was not instructed as an expert, but which proceeds on the basis that this does not matter and that his evidence in criminal proceedings can be looked at in isolation from the manner of his instruction or how he was used by Post Office. That would not be a sustainable forensic exercise and would be unfair for these reasons. First and fundamentally, Mr. Jenkins was not being treated as a witness of fact. He was being asked questions to undertake work, to respond to expert reports in Mrs. Misra's case and to provide opinions. In short, he was being asked to provide evidence and being put in a position that no witness of fact would be put in. As stated already, the evidence that he gave and how he gave it was a product of Post Office's approach to him, and specifically the product of communications which Post Office had with him about what his evidence was to address. It is impossible to disentangle these from each other, and it applies to every single case study. Third, it would also overlook the evidence that Mr. Jenkins, it would also overlook that the evidence that Mr. Jenkins gave was in the context of a series of grossly defective communications which misrepresented his role and the sort of evidence that he was to give. Again, this was a feature of every single case study. Far from prosecutors sending the message that Mr. Jenkins was to be treated as independent, or, for example, his evidence is independent, they informed him, for example, you are our Horizon expert, you're an expert for Fujitsu, that he rebut and disprove or discredit what the defence were alleging, that he preserve the Horizon system. These are just examples of what lawyers told Mr. Jenkins that his role was. And yet, despite that, Mr. Jenkins provided precisely the sort of information to Post Office that he is being accused of having withheld. This was an approach in 2012 on the part of both Mr. Singh and the Cartwright-King lawyers, which Mr. Atkinson King's counsel described as woefully inadequate, or the antithesis of how an expert should have been instructed. Fourth, Mr. Jenkins was also, in his purported capacity as an expert, being asked to undertake functions which were those of the prosecutor and which he should not have been asked to do. I will deal with disclosure as a separate topic. But, for example, you know, sir, that he was sent the defence case statement in Mrs. Misra's case and in Mr. Ishak's case asked to comment on it. That should never have happened. It is the prosecutor who is charged with the statutory obligation of considering disclosure in light of a defence case statement. It is not the duty of a witness. And you might think, sir, that that was just another example of Post Office delegating to a witness functions that were its. Fifth, the unfairness of this approach that is, of treating it as irrelevant that Mr. Jenkins was not instructed as an expert, is that it would hold Mr. Jenkins to the standards and duties of an expert witness when he was a lay person, uninstructed and uneducated in those standards and duties. Sixth, this approach would negate the importance attached to the duties on lawyers when they instruct an expert to ensure that they understand the content of expert duties. So that is all by way of introduction, and I wanted, if I may, to deal with some specific points. But before I do so, to thank the inquiry, and particularly all of those whose very hard work has enabled a forensic reconstruction of how a number of the case studies were prosecuted. It's only by that process that it's been possible to demonstrate that Post Office failures in relation to Mr. Jenkins were part of a much broader canvas of prosecutorial failure. Of these failures, the most significant which relate to Post Office's use of Mr. Jenkins is its failure to understand that the Criminal Procedure and Investigations Act applied to it as a holder of material relevant to its prosecutorial function. In other words, sir, the Post Office elected to prosecute at scale without ever having understood that it had a statutory obligation to ensure that information it held about the operation of Horizon was retained and recorded and potentially revealed for the purposes of the CPIA. The second is Post Office's failures to make properly considered and properly formulated third-party disclosure applications to Fujitsu. The third significant failure is that investigators and prosecutors consistently did not discharge their statutory obligations under the CPIA in individual cases. In other words, that information or material that fell to be included on unused schedules was not recorded on them and was not disclosed to the defence. This was a feature of every single case study in which Mr. Jenkins featured. Had that happened, had drafts of his witness statements or communications with him been listed on the unused schedule, then the picture would be a profoundly different one. The fourth, sir, is the failure on the part of every Post Office investigator, lawyer and external lawyer in the case studies in which Mr. Jenkins featured to discharge the obligations on a prosecutor where they seek to rely on expert evidence. Returning to Mr. Jenkins and setting him against this canvas, well, despite his being a Fujitsu engineer, despite his lack of experience, all of that, there was no recognition on the part of any lawyer that this made it imperative that if he was going to be relied upon as an expert, that first, he was actually instructed as one. Second, that he understood that his evidence had to be independent, that he was providing evidence to the court, not on behalf of Fujitsu or Post Office, that this made him subject to the special expert duties, what those duties were and how they applied to him, and in particular, how the duty of disclosure might apply to him and how he might go about discharging that duty. As Mr. Atkinson put it, even with the professional expert witness, even if you are singing to the choir, a prosecutor instructing an expert should ensure that they understand these duties to which they are subject. It is just extraordinary that no lawyer ever saw any need to discuss with Mr. Jenkins the very distinct and unusual position that he was being put into. The instruction of an expert is usually a carefully considered step in litigation, not undertaken lightly. The discipline of drafting a letter of instruction means that proper consideration is given to what the expert is being asked to address. This isn't advanced lawyering. This is the material of everyday work. In 2005 and 2006, the subject of expert evidence had been an intense focus on the part of the Court of Appeal. Criminal lawyers had been reminded that the Akarian reefers applied to criminal litigation. This, in turn, had been reflected in the criminal procedure rules. And in March 2006, the CPS produced its own guidance specific to how experts were to discharge the duties of disclosure when they were instructed by the CPS. And that guidance, pithy though it is, encapsulated core concepts. Concepts like recording, revealing, and retaining. It explained what unused material was. It explained the requirement that the expert retain everything that they generated in the course of their work. For example, explanations that they had been provided with. The CPS discharged its obligations to ensure that the expert understood this by requiring them to sign a declaration of understanding. So if Post Office was going to use powers of private prosecution against sub-postmasters, to do so routinely and knowing that it put them at risk of conviction, of imprisonment, of financial loss, why wasn't Post Office or its prosecutors abiding by Court of Appeal judgments, by the criminal procedure rules, or promulgating this sort of guidance? What does that say about the culture and ethos of the organisation and the lawyers within it, that they saw no need to apply this law to their prosecutions? This may go to a point I understand my learned friend Mr. Maloney to make, that it is suggestive of some sort of sense of exceptionalism. But whatever you might conclude, sir, Post Office just didn't have this kind of guidance. In fact, a series of investigators and lawyers lined up to tell you that they did not know about the duties on them when they instructed an expert. So I'm going to deal, if I may, swiftly with some matters of chronology. So first of all, as regards, and I start in 2005, sorry, I should have said, with Mr. Castleton's case. And about the 2005 Bond Pierce letter. You'll recall, sir, that this was a letter addressed to Fujitsu in November 2005 and related to Mr. Castleton's proceedings. Time doesn't permit me to deal with that at any length, but I notice that none of the core participants have sought to seriously contend that this letter put Mr. Jenkins on notice that expert duties applied to him, still less that it would have meant that he understood the content of expert duties, how they applied to him, and that he would have carried this knowledge with him in the years to come. It is dealt with in the written submissions on his behalf, but the fact alone that it was sent to Mr. Jenkins when it was not in contemplation that he would be a witness may be the best indicator that it wouldn't have seemed terribly significant to him at the time. So, of course, in the Castleton litigation, it was decided that Mr. Jenkins would be a witness of fact, and on that basis, Mr. Dilly prepared a statement for him. Mr. Jenkins refused to agree to making the statement, that there were no grounds for believing that the problems that Mr. Castleton said he experienced with his computer would have caused either theoretical or real losses. As Mr. Jenkins noted on the statement, this was not something he felt able to agree with, without looking more closely at what had gone on. So this is a complete answer to the allegation made by my learned friends Mr. Maloney and Miss Patrick in their written submissions, that Mr. Jenkins had been a party in Mr. Castleton's case to Mr. Pinder's obvious attempt to remove ambiguity or nuance from Fujitsu's message, in that case, that the problem was not theirs but the SPM's, or to avoid a close examination of the data. It was exactly that, a close examination of the data, which Mr. Jenkins was advocating was needed in Mr. Castleton's case. So we have dealt with Mr. Jenkins' willingness to use the term system failure in Mr. Thomas's case, and that the opposition to it was entirely that of Mr. Ward in written submissions. So I won't expand on that orally. But, sir, I did wish, through Mr. Thomas's case, to make some submissions on the issue of the boilerplate paragraphs. So we invite the inquiry to consider with care any claim that it was understood by Post Office lawyers or investigators that the boilerplate paragraphs were attesting to the integrity of the Horizon system. These paragraphs were a standard part of every statement made by Miss Lowther and Miss Thomas when they produced the ARQ data. Miss Lowther and Miss Thomas were not technicians. The idea that by producing this ARQ data, which is understood would normally have been for limited periods, they would have understood themselves to be attesting to the integrity of the entire system seems far-fetched. So the inquiry did not hear from Miss Lowther or Miss Thomas, so it has no direct evidence from them as to what they understood the boilerplate passages to mean. And in respect of Miss Thomas, this is particularly significant given that she wrote the litigation support manuals in force at important times. However, the evidence strongly suggests that these boilerplate passages related to their production of the ARQ data. Indeed, it's respectfully submitted, sir, this must be correct. First, for the reason just alluded to, that neither of them could possibly speak to the overall integrity of the system. And, sir, I use that term cognizant of the fact that it's not a term of art and it doesn't have a statutory meaning. Miss Thomas and Miss Lowther could, however, speak to the process by which they had extracted the ARQ data. The standard statements producing the data set out the processes which resulted in the data being stored in the audit server and the processes by which the ARQ data was produced. In other words, the substantive content of the statement was consistent with the ability of them to attest to the production of the ARQ data. The Fujitsu manuals provided for a detailed process-driven mechanism by which the ARQ data was to be produced. The manuals did not provide at all for any other process which needed to be gone through in order to make the boilerplate statements. It's unthinkable that guidance intended to regulate the making of the statement for producing ARQ data would make detailed provision for that, but not provide any guidance to non-technicians as to how they were supposed to attest to the overall working of the Horizon system. You may not have heard from her, but you do know that Miss Thomas's line manager, Miss Munro's understanding, in her words about the boilerplate paragraphs, was that they were in regards to the audit workstations where they retrieved the data from, rather than the integrity of the Horizon system itself, how they pulled the data off, rather than the Horizon system. This was something that Mr. Lenton, heavily involved in the civil proceedings, also said. My understanding is that it's referring to the audit retrieval system. You didn't understand it to be a generalised comment about the integrity of the system, no. Finally, Duncan Atkinson, King's Counsel, agreed that the meaning of the boilerplate paragraphs was not altogether clear, at least open to interpretation. So if Mr. Duncan Atkinson considers that they are open to interpretation, it should give real pause before the conclusion that they are only capable of one meaning is arrived at. Returning to Mr. Jenkins, the boilerplate paragraphs were in the draft statement that Miss Lowther prepared for him in Thomas. As he explained in his inquiry statement, having queried how he could include these paragraphs when he had only been provided with the spreadsheets of the zero transactions, he believes that he would have spoken to Miss Lowther and Miss Thomas about them. He sought to explain in his oral evidence what he thought these paragraphs meant in his statement in Mr. Thomas's case. And he did explain that he thought the paragraphs related to the computers involved in the production of that, so not just the typing up, but actually the extraction of the ARQ data as well. So asides the point in Mr. Thomas's case that he was only commenting on the zero transactions, Mr. Jenkins was emphatic that he would not have described the Horizon system as a computer. It simply wouldn't have made any sense to him. So I turn then to Mrs. Misra's case. What emerged clearly from the evidence in Mrs. Misra's case is that Mr. Jenkins was being asked to do three separate things. He was being asked to deal with Post Office's disclosure obligations under the CPIA, but never actually told that. He was being asked to respond to Professor McLaughlin's reports, and he was also being asked, in Mr. Tatford's words, to assist Professor McLaughlin. Over time, those three things became conflated and confused. For all of the reasons set out in our written submissions, insofar as Post Office sought to discharge its disclosure obligations through Mr. Jenkins, this was an impermissible delegation of its statutory duties. But that aside, Post Office did not tell Mr. Jenkins or Fujitsu that it was doing this. It didn't explain to him or Fujitsu what its disclosure obligations were. It did not explain to him or to Fujitsu what might be potentially relevant. Relatedly, prosecutors did not address the capacity in which they were using Mr. Jenkins. Mr. Tatford conceded this. Neither he nor Mr. Singh confronted what their reliance on Mr. Jenkins amounted to. There was no point at which this crystallised in Mrs. Misra's case. According to Mr. Tatford, until Mr. Jenkins came to provide his final statement, he was not being treated as an expert witness. This is what Mr. Tatford called the muddled thinking about Mr. Jenkins' role, which, in his words, tarnished the thought process throughout Mr. Jenkins' instruction. And I regret that. It was a mistake. And in an important passage of his evidence, he went on to explain, when he was asked why none of the statements had the necessary content to be expert statements. He said that he thought that they should have been in all of the statements, and that he thought this at the point at which the final statement was made. He thought that the final statement should have complied properly with the CPR, but it didn't because there was only 2 days left before trial. Of course, so that statement did omit the necessary content, and Mr. Tatford's explanation doesn't make much sense when one has regard to the fact that he was able to make quite extensive comments on that draft statement and suggest that Mr. Jenkins said, which Mr. Jenkins said no to, that it was more likely that Mrs. Misra had stolen the money than that the loss could be explained by computer error. And again, sir, you may reflect on what that says about Mr. Jenkins. Also important in this regard is his concession that in seeking to change what Mr. Jenkins said, that this was not consistent with the concept of Mr. Jenkins as an expert evidence. And sir, you'll have in mind what Mr. Tatford finally said in his evidence, that he felt worse because it had been quite clear in the way that the evidence was properly put before him, that there were many failings that he had ignored on his part, and perhaps created a rosier version in my memory that wasn't really there. So despite the series of defective communications with him, Mr. Jenkins provided to Post Office the sort of information it purported to be seeking. Mr. Jenkins provided information to prosecutors which was never explored. Neither Mr. Singh nor Mr. Tatford asked any questions when Mr. Jenkins said he couldn't give a clear answer to whether there were problems with Horizon. They never asked any questions about the locking problem which caused transactions to be lost, still less ensured that this was recorded on the unused schedule. Neither asked about the process by which Fujitsu checked NT events. Mr. Singh and Mr. Tatford were well aware that Mr. Jenkins didn't know anything about the Calendar Square bug, but didn't ask what records Fujitsu kept of previous issues that had affected accounts. It was Mr. Jenkins who had to press and press in the face of resistance that the ARQ data from Mrs. Misra's branch be obtained, and that, for example, the full message store be provided to Professor McLachlan. The argument that he sought to withhold information about bugs and problems in Horizon is wholly undermined by the fact that he informed Professor McLachlan about the known error log and the 200,000 faults on the test and live system. Mr. Jenkins also informed the prosecutors that Fujitsu might be able to provide Professor McLachlan with the information about the system changes sought in the disclosure request. By 18th of August 2010, Mr. Jenkins spoke to his colleagues within Fujitsu and told them what he thought this exercise would involve, including the collation of peaks and change proposals. In other words, Mr. Jenkins put into motion the scoping exercise to provide Post Office with all of the peaks related to the issues which had required changes to be made to the counter. This is precisely the sort of information which Mr. Jenkins is being criticised for not having provided, yet it was there for the taking by Post Office. And the only reason why it wasn't is because Post Office refused the defence requests for disclosure of that information in Mrs. Misra's case. So I'm going to deal finally with the receipts and payments mismatch bug, a bug that Mr. Jenkins was accused by Post Office of not disclosing. As this inquiry has uncovered, in fact, Post Office lawyers were well aware of it and decided that it did not need to be disclosed in Mrs. Misra's case. The Court of Appeal was not told that. Mr. Jenkins was emphatic that from his technical perspective, a bug that occurred in Horizon Online in 2010 had no logical connection with Mrs. Misra's case, that she experienced problems in Horizon in 2005 and 2006. His was the technician's perspective. The inquiry can now assess the position, knowing that the issue wasn't that Mr. Jenkins concealed that bug from Post Office. Indeed, it was well known about and the options for remedying it within Post Office. It can assess the position knowing that those statutorily charged with making disclosure decisions elected not to disclose it. The main point which appeared to be put by my learned friend Mr. Henry King's counsel about the receipts and payments mismatch bug in relation to Mrs. Misra's trial was that it wasn't disclosed because it would have revealed the possibility of remote access. So that argument assumes that Mr. Jenkins would have thought that the fact that there was remote access into Horizon meant that cases couldn't be prosecuted, or that revealing the fact of remote access would have had a significant impact upon prosecutions. There is no evidence that Mr. Jenkins ever thought this. Indeed, the fact that he made the statement in the Wiley case in 2012 confirming that there was remote access is to entirely opposite effect. There is no evidence that he knew that remote access was ever done in a way so that the SSC left no trace of it in the audit trail. Mr. Jenkins was sent a single email by Mrs. Chambers in 2006 when she mentioned access at the counter. There's no reply from him, and he's not mentioned in the subsequent peak. But there is nothing in that email to suggest that access at the counter meant that the SSC obtained access and changed data, but didn't leave any trace of that in the audit trail. In his paper, in the RMP mismatch bug, Mr. Jenkins set out a proposal for the correction of the data at each branch and said we need to agree a timetable with Post Office to correct the other branches and ensure that this is communicated with the branches to ensure that everyone is happy. Put shortly, Mr. Jenkins foresaw a process of correcting the bug as one which entailed the consent of both the Post Office and the affected SPMs. His note did not refer to any ongoing prosecutions, still less any concerns about them. So I turn briefly then to 2012. So there is no doubt that the generic statement conceived by Mr. Barrier of Cartwright King was part of a response to the commission of the second site review, and that it was poorly conceived. Mr. Atkinson regarded the approach taken, in other words, to formulate a general statement which could be served in any case in which Horizon was raised, as inconsistent with the duties of a prosecutor, because fundamentally it meant that prosecutions were not being considered on a case-by-case basis. Mr. Bowyer formulated the 4 questions that Mr. Jenkins was to answer. In order to answer these questions, Mr. Jenkins was sent the Helen Rose report and spreadsheet. In other words, information that Post Office had gathered about cases it had prosecuted in which Horizon issues had been raised. It is wholly unclear why anyone thought that Mr. Jenkins should be providing evidence about matters which were wholly within the provenance of Post Office and unconnected with him. Again, you might think another attempt to delegate to him matters for which Post Office was responsible. In terms of the email that Mr. Singh sent Mr. Jenkins, instructing him, so to speak, well, so that's the email that you've already heard described as the antithesis of how any expert should be approached. Mr. Jenkins provided his answers to the questions by way of a technical Fujitsu report and sought the input of others. However, they and he clearly understood that it was to be expressed at quite a high level, reflected in its content. Mr. Jenkins provided the overview sought as to how the Horizon system worked. He explained that he had no knowledge of 21 of the cases that Miss Rose referred to. That report was in turn turned into the witness statement and subject to editing by Post Office and Cartwright King lawyers. In particular, the part of the report that explained that Mr. Jenkins didn't know about the vast majority of cases that Miss Rose alluded to was taken out. Consistent with Mr. Jenkins' report, the statement continued to explain the Horizon system at a high level. It explained the challenges to Horizon that Mr. Jenkins himself was familiar with. The evidence does demonstrate that Mr. Jenkins wasn't clear about the use to which it was going to be put. Miss Jennings' contemporaneous email of the 19th of October 2012 said that she had put the statement into a Section 9 format, and that she had been in contact with Mr. Jenkins, and that he didn't know that it related to a specific case, and that he wasn't aware that he would be required in court. It was after this point that Mr. Jenkins was contacted by Miss Panter and told that she intended to use his statement. It was in that email that she told Mr. Jenkins, it doesn't matter that you haven't mentioned a specific case in your report, because there haven't been any specific criticisms raised by any of the defendants provided in my list of cases. It's important to be clear, sir, that what Mr. Jenkins was being told by the prosecutors was that his generic statement would be used in cases in which no specific criticism of Horizon had been made. Those representing the Hudgell's Court participants submit that the generic statement itself demonstrates that Mr. Jenkins' position was always to start with a set view of likely evidence. But this isn't correct, because the evidence in the Allen, Sefton and Neild and Ishak cases show that Mr. Jenkins made clear when Post Office were proposing using the generic statement, having been told that no specific criticism was made, that he pressed that ARQ data could be obtained for those branches and what it might show. In Mr. Allen's case, he made clear to Mr. Bolts that the ARQ data could demonstrate exactly what had happened. Mr. Bolts understood that. He communicated to Mr. Bradshaw, Gareth tells me that it is in fact possible for him to retrieve the actual data to see what actually occurred in the branch. But Mr. Bolts said no to obtaining that data. And similarly in the cases of Miss Sefton and Miss Neild, Mr. Jenkins suggested the issues that could be looked into, but again, Mr. Bolts rejected obtaining the audit data. In summary, in these cases, despite being told that they did not raise Horizon issues, Mr. Jenkins went on to explain what the ARQ data could be used for. And Mr. Atkinson observed of this, that what Mr. Jenkins was offering to undertake would have been more in line with Post Office's duties as a prosecutor, both in terms of reasonable lines of inquiry and disclosure, and that the refusal to do this was clearly a missed opportunity for which little justification was offered. So I don't have time to deal with the disaster that was the prosecution of Mr. Ishak, but it says everything about how Cartwright King conducted prosecutions. It suffices for my part to remind you today that Mr. Jenkins was asked to turn up on the first day of that trial in order to deal with a defence expert, in circumstances where he had seen no defence expert report and hadn't even been provided with any of the materials that the defence expert had. He spent the first day and night of the trial trying to ascertain the extent to which he agreed with Miss Abbotson's analysis as to how the loss figure had been calculated. And so I remind you again of what Mr. Atkinson Casey said about this in his usual understated terms. Well, it's moderately remarkable to expect any witness, but certainly an expert witness, to deal with complex issues and to try and narrow down those complex issues with another expert, not knowing what the expert said, not knowing what material they had seen, not being able to check either anything that they had said or that they have seen. I can't quite think how anyone thought that was a good idea. So it's very hard to see how Mr. Jenkins could be responsible for what happened in the Ibbotson case. He came to court and he did his best to deal with the situation that confronted him. So may I end by saying this? And so you're probably smiling at me because you know that my R is about up.
I have a very reliable timepiece here, Miss Dobbin.
Can I? Well, maybe your reliable timekeeper will be
I'll allow
slightly
you a
less
conclusion.
reliable for a couple of minutes.
Don't let's lose time for
No,
you.
of course. Sir, a public inquiry isn't a trial. The rules don't require allegations to be put to witnesses. It's not unusual for different theories to be put to witnesses, or even inconsistent cases to be put to witnesses by different court participants. But in respect of Mr. Jenkins, if the allegation is that he failed to disclose bugs or was part of an effort to convey Horizon as infallible, or that he sought to conceal that there was information available that would reveal problems in Horizon, or to conceal that there were investigations that could be carried out at a branch to investigate what may have happened, then those points are, in my respectful submission, unsustainable, having regard to his consistent approach. Starting in March 2006, with his being entirely happy to use the language of system error in his statement in Mr. Thomas's case, his genuine lack of understanding as to why Mr. Ward had any problem with the use of those words. It's demonstrated by his providing an explanation of the peak system in his draft statement in Mr. Thomas's case, explaining quite openly Fujitsu have a fault management system called the peak system, which is used for passing faults around the team and tracking faults raised regarding the post office account. It's demonstrated by, in May 2006, his unwillingness to sign up to the language of Mr. Dilly in Mr. Castleton's case, unless there had been an examination of the data. It's demonstrated in February 2010 by his absolute insistence in Mrs. Misra's case that the branch data be obtained so that he and Professor McLachlan could examine it, in the face of pull resistance that had been going on for months by that point. It's demonstrated again in February 2010 by his immediate answer in Mrs. Misra's case, whether there are known problems, that yes, he could not make a clear statement because transactions could be lost due to locking issues. It's demonstrated in March 2010 by his suggestions at the end of his statement on the 9th of March about other aspects of the data that could be looked at in Mrs. Misra's case. It's demonstrated in July 2010 by the information which Mr. Jenkins gave to Professor McLachlan and which led directly to the defence requests for the disclosure of the known error log, the system change requests, the new release documentation, again by his guileless reference to the fact that there were 200,000 faults in the Horizon system. It's demonstrated in August 2010 by the fact that Mr. Jenkins was willing to undertake and set in motion an assessment of what he thought could be provided to the defence, including every counter-release applied to the live estate in the last 7 years. A list of the peaks, the change proposals that had been addressed in that period. Again, I remind you, sir, it was Post Office who refused to disclose that. It is demonstrated in October 2010 by his provision of the peak in the Callender Square case to Professor McLachlan. It's demonstrated again in October 2010 by his objections to the changes that Mr. Tutford had proposed to his witness statement, including that he refused to give an opinion to the effect that it was more likely that Mrs. Misra had stolen money than the loss being explained by a computer error. It is demonstrated again by the evidence he gave at Mrs. Misra's trial, which was modest and which made clear its limits. It included his acceptance that there could be Horizon issues that he didn't know about that could have affected Mrs. Misra's branch, given that he hadn't known about Callender Square. His caveated response to the question whether he had seen the slightest symptom of a computer fault at West Bay Fleet. His answer, I've been doing the sort of high-level rough analysis of this stuff. His concession that he had no way of knowing whether money was lost due to theft, and that he could not say that any money had been lost in Mrs. Misra's case. It's demonstrated in September 2012 by his mindset and approach towards Second Sight and openly discussing bugs in Horizon and remote access with them. It's demonstrated by what he said in the statement in Miss Wiley's case. It's demonstrated by his approach in October 2012 and February 2013 by his attempts to explain that there was ARQ data that he was willing to examine and which might show what had happened at the branches in question. So Mr. Jenkins was an engineer in a legal world. He was navigating it without essential tools that he ought to have been provided with by Post Office and by Fujitsu. Despite that, and despite the obstacles put in his path by lawyers, he took an honest technician's approach, providing the information that Post Office purported to want. The issue was not the lone expert, it was Post Office and its lawyers.
Thank you.
Thank you.
We'll start again at 2:15. No, 2:20. Well, no, I think 2:15 is okay. 2:15 for Mr. Chapman. Mr. Chapman.
I make this closing statement on behalf of the Department of Business and Trade.
No.
So might I suggest that Mr. Chapman swap seats and comes forward, perhaps, to the seat that Mr. Maloney normally occupies?
Far be it from me to think that Mr. Henry has deliberately muted him.
Ms. Pepper, can you confirm this one's working? This one is? Yeah.
Yeah.
Right, is that better? Yes.
Can you see him, David?
Right, trying again. So I make this closing statement on behalf of the Department for Business and Trade. As the Department has stated on many occasions in the course of this inquiry, in Parliament and elsewhere, the Horizon scandal is truly appalling. No one in this room needs reminding of the devastation to so many good people's lives, the trashed reputations, the financial ruin, the dreams unrealised, the chances lost, the families and communities weakened and divided, and of course innocent and good people thrown in jail, and in those especially tragic cases, driven to suicide. The Post Office itself bears principal responsibility for this scandal, but it did not act alone. Indeed, as a corporate body, the Post Office was a manifestation of its people and the culture that they inculcated and embodied. It acted in the despicable way that it did because of the choices of those people, individually and collectively. And this scandal involves a cast of characters from inside and outside the Post Office, including, but by no means limited to, the Post Office board and executives, staff in its branch support, communications, IT and security and investigation teams, employees of Fujitsu, the NFSP leadership, central government and its agencies, and perhaps most invidiously and reprehensibly of all, lawyers. All contributed in their own way to this scandal. For the Horizon scandal is not merely about hopelessly buggy IT software, unchecked back doors, poor quality hardware, superficial training, and a helpline that provided anything but help. Those were certainly causes, but they were not the only causes. For the Horizon scandal is also a story of false assurances, of a culture of secrecy, of spin doctors, of untruths and half-truths repeated as mantra to board members, officials, ministers, MPs, and the great British public, of institutional and individual arrogance, incompetence, dishonesty, and cover-up, of misleading official advice, of false testimony, of disclosure failures, of bad lawyers. Most of all, perhaps, it's a story which has its origins in the Post Office's corporate attitude of contempt for the very people who are the face and the heart of the institution. The department does not attempt to shirk its share of responsibility for the mistakes which allowed this scandal to happen. As the Post Office's sole shareholder, the department recognises that it is ultimately accountable for the actions perpetrated by the Post Office. The simple and inescapable truth is that it failed to prevent this scandal from happening. And the department is responsible for the system of oversight over the Post Office which was in place. For reasons which have been thoroughly explored by the inquiry and which I'll go on to address, that system failed to provide adequate scrutiny and challenge in relation to Horizon, and ultimately it failed to escalate and expose the right information to the right people in government. The shareholder executive, SHEX, was until 2016 a directorate within the department itself, and therefore the department must accept direct responsibility for SHEX's failures, whether structural or individual. The fact that SHEX's functions were assumed by UKGI in 2016 does not absolve the department of responsibility for mistakes after that point. The department recognises that it retained ultimate responsibility for overseeing the Post Office, and that it was ultimately responsible and accountable for the arrangements in place for doing so. That the department delegated its responsibilities to UKGI, which acted essentially as its advisor and agent, does not change that fact. Similarly, the department recognises that a focus on the organisational niceties within government may give the appearance of shabby internal buck passing. It's essential, of course, for the inquiry to consider carefully the organisational mechanics that allowed this scandal to happen, so that the right lessons can be learnt for the future. However, as the only central government department with core participant status in this inquiry, the department wishes me to state clearly and unequivocally that wherever within this organisational structure the finger of blame may point, be that the Post Office, SHEX, UKGI or the department itself, the government accepts ultimate responsibility. The department has offered its sincere apologies for its role in this dreadful scandal. Whilst its recognition of these failures cannot change nor atone for the devastation inflicted on postmasters and their families, the department hopes that its and the government's genuine commitment to learning the lessons of this tragedy will go a long way to preventing its recurrence in future. The 8 issues that I intend to address in this closing statement are, in turn, procurement, development and rollout of the Horizon IT system, the organisational structures for management, governance, oversight and accountability, breaches of trust and the duty of candour, the culture of the Post Office, SHEX and UKGI's two-hatted role and the perception of conflict, the broader legal and regulatory ecosystem, redress and cultural transformation. I turn first, and relatively briefly, to the birth of Horizon, its procurement, development and rollout. As you'll remember, sir, several departmental and other central government witnesses gave written and oral evidence to the inquiry during Phase 2, and the department provided a detailed written closing statement at the end of that phase of the inquiry. From the department's perspective, the main headlines to emerge from that evidence were as follows. First, during the 1990s, it was almost universally recognised and accepted that the development of an integrated electronic point of sale and accounting system was absolutely necessary to preserve the post office network and the livelihoods of postmasters. The underlying aims and objectives of the Horizon project were readily understandable and indeed laudable. But there were serious problems from the outset in the way in which the Horizon project was organised, in large measure flowing from a failure to agree on specifications at an early enough stage. The three-way contractual relationship led to predictable difficulties with each of the contracting parties, the Post Office, the Benefits Agency, and ICL Fujitsu, having different and not easily reconcilable ambitions for the system. As Sir Adrian Montague explained when giving evidence to the inquiry, the PFI contractual relationship was a poor fit for any IT procurement, especially one of this scale and complexity, and really required much more detail and specificity than was in the Horizon contract. And the fact that the requirements for Horizon changed materially during the development phase, the biggest example being the cancellation of the benefit payments card functionality, was symptomatic and undermined the smooth running and delivery of the project from early on. But none of this meant that Horizon was irredeemable. As the expert reports commissioned by the government at the time made clear, the project remained, to quote, technically viable. Sir Adrian Montague explained that this meant that it was possible to develop the system so that it met the specification at the point it was to be rolled out. And as Lord Mandelson stated in evidence, the alternative to progressing with Horizon was very unclear, technically and financially, and it was accepted that cancellation would have been a significant setback to the modernisation of the Post Office. And so, armed with this knowledge, pressing on with the project made sense at the time. However, ministers realised the experts weren't giving what they described as, what Stephen Barr described as a blank cheque going forward. And they did not merely leave it to the Post Office to ensure that its new IT system would work. It was for this reason that they, ministers, insisted, despite Post Office resistance, on a live trial in 300 post offices before contractual acceptance. They also set up the Horizon Working Group with the specific purpose of hearing the voice from the front line, a forum for postmasters through the representative bodies and other stakeholders to raise technical and practical problems with Horizon directly with government ministers. These were sensible measures and could have had a genuinely revelatory role, and it is surprising and regrettable, to put it lightly, that the NFSP leadership chose not to alert the government to their members' concerns about bugs and other technical problems in the working group or elsewhere. Its failure to do so defeated the whole purpose of the working group and actively provided real and material, but false, reassurance to the government. And the NFSP continued to act as a vocal defender of Horizon over the years that followed. When, in late 1999, the then Minister Alan Johnson was informed of issues with Horizon's system stability, accounting integrity and support, he immediately intervened and had rollout paused for an extended period so that the issues could be resolved. It did not recommence until he was given assurances that these issues had been or were being resolved satisfactorily. Sir Ian McCartney and David Sibic both considered, with the benefit of hindsight, that on an IT project of this size and complexity, the government should have commissioned a further independent and expert review to confirm that Horizon was indeed fit for purpose at the point of rollout. That may well be right, and clearly in the hindsight knowledge that Horizon was not fit for purpose at the point of rollout, a further expert report or reports may well have helped expose and resolve problems at that stage. At the same time, of course, the line needs drawing somewhere. The inquiry will no doubt wish to evaluate whether the information available to the government at the time should necessarily have led it to commission such further reports, with the attendant further delays and uncertainty for postmasters. There was here a balance. The procurement, development and rollout of Horizon took place in the very early days of PFI government IT projects, and it's not the only government IT project ever to have gone wrong. Whilst it's clear that many lessons have been learnt along the way, with many success stories, the Passport Office being a good recent example, IT procurement and development in government remain difficult and complex. The history of the Post Office's project to replace Horizon, despite the shortened arm and more intensive government scrutiny of the Post Office over these past few years, is a good illustration of things going wrong, though of course that's a project managed by Post Office and not central government directly. For now, the point is that the government realises that it needs to look hard at where things have gone wrong in some of its major IT projects, including Horizon, and to think creatively as part of a non-stop effort to improve. Pat McFadden, Chancellor of the Duchy of Lancaster, commented in his UCL speech last week about the benefits of the small-scale, nimble and enterprising test and learn approach favoured by successful private tech. That may offer one possible solution. The government would welcome other ideas. I turn next to the organisational structure. In other words, the formal systems of Post Office management, governance, oversight, and lines of accountability, including in relation to the management of risks. As Mr. Sheldon said yesterday, the importance of this issue is difficult to overstate, though we realise not altogether exciting. The department set out in some detail its observations on the structure that was in place during this scandal, and I don't intend to rehearse those observations in very great detail now. I can summarise it as follows, starting with the arm's length arrangement. For over half a century, the Post Office has existed at arm's length from government. With the passage of the Postal Services Act 2000, Parliament decided to maintain and indeed strengthen through legislation the Post Office's operational independence, free of government interference. The autonomy and independence given to the Post Office was and remains a specific parliamentary objective for which the practical and principled reasons are readily apparent. First, that ministers have neither the time nor, generally, the expertise to get involved in running large and complex commercial organisations such as the Post Office. And second, to enable the Post Office to operate as a commercial business free of incessant government interference. There was almost universal consensus amongst witnesses that the arm's length model remains the only sensible option for the Post Office for so long as it remains in public ownership. The department agrees. The arm's length legislative arrangement implied a presumptive starting point that ministers should not get involved in operational matters. The department's view is that, as a starting point, that was good and sensible, and indeed necessary. But Scheck's UKGI officials were wrong to treat this as inflexible dogma. It was always open to ministers to scrutinise and challenge the way the Post Office was conducting its operations, and to use the levers that were available to them if they were unhappy with what they saw. The general thrust of the evidence is that ministers understood this and did get engaged whenever they thought it appropriate based on the information available to them. As I'll go on to explore, the operative problem was not some arid concept of strict strategic operational divide. It was that the ministers were not given the information they needed, and so did not realise there was a problem that required their attention. In fact, they were consistently managed, misled, and deceived. Ministers sat towards the top of a pyramidal structure of management governance, oversight and accountability typical of and necessary in any large and complex organisation. At the bottom of that pyramid were central post office employees, for example, members of its branch support, communications, IT and security investigation teams. They reported to and were managed through a number of increasingly senior management tiers up to, ultimately, the Post Office executive team, led by the CEO. The executive team were overseen by the Post Office Board of Directors. The Post Office Board of Directors was until 2012 overseen by the Royal Mail Board of Directors. The Post Office and/or Royal Mail Board of Directors was overseen by the shareholder team at the government's Corporate Governance Centre of Excellence, first SHEX and thereafter UKGI. SHEX UKGI reported in relation to the Post Office to the junior minister and in extremis to the Secretary of State. And ministers and the Secretary of State were scrutinised by and accountable to Parliament and through Parliament, the British public. This was not a system that lacked tiers of oversight. And in common with the witnesses who spoke about this structure, the department believes that these arrangements were broadly appropriate, with one caveat that I'll come on to later. But there are two really critical points here. First, the Post Office Board of Directors was and remains the body with principal and direct responsibility for overseeing the activities of the Post Office. This was the clear and consistent view of the inquiry's own experts and of the senior UKGI witnesses. Each additional tier of oversight, in turn SHEX UKGI, ministers and Parliament, has an increasingly high-level role, inherent in the increasingly wide range of responsibilities falling within their domain. And their job is not to redo, review, or second-guess all of the work of each of the tiers below them. As for the ministers, the evidence indicates that they are busy to an extent and with such a range of issues that is almost impossible for most of us to imagine. Their role was essentially to satisfy themselves that an appropriate structure was in place beneath them, and then to decide, based on the information available to them, where to focus their own time on the issues arising across their portfolio. And second, any organisation depends on honest and truthful flows of information up through the lines of management and oversight. And as part of that, it requires honest and truthful information in response to scrutiny and challenge from the tiers above. Sir Ed Davey expressed the point as follows: our system of government is essentially built on the assumption that people in positions of trust, such as the leadership of the Post Office, tell the truth. The right to expect timely and accurate information should be self-evident and was emphasised time and again by the various witnesses, including senior UKGI officials, permanent secretaries, ministers and secretaries of state, and the inquiry's governance experts. Governance and oversight structures can only do so much. As Dame Sandra Dawson put the point, a framework cannot control behaviour. It sets the boundaries and sets the expectations. Sir Alex Chisholm made the same point more directly. No structural solution, he said, can fully deal with the realities of the situation, which depend on the quality of the people you have in there and their dealings with each other. I said before that there was a caveat to the department's view that the overall governance and oversight system was the right one. Its reservation relates to the absence at the relevant times of an internal departmental policy unit working in parallel with SHEX UKGI in its devolved role as corporate governance experts and shareholder representative. This reservation arises with hindsight. Several witnesses have observed how simply putting in place more tiers of oversight is not a panacea, and indeed may, in many cases, act as a hindrance to good governance. Dame Sandra Dawson emphasised more than once the downsides to multiple governance and oversight tiers and the importance of the unitary board of directors taking proper ownership and accountability for the company. Sir Martin Donnelly explained that, to quote, "When you have the level of complexity that we're dealing with, you have to be able to empower people to take decisions and follow them through in a structure, because otherwise you're not going to get effective outcomes." And that the challenge of adding additional layers is if you do not have additional information on which to base your challenge, it can merely add bureaucracy and actually make it more difficult to get at the truth. But it's also clear, in retrospect, that additional oversight of the Post Office from a departmental policy team may have led to greater or more astute scrutiny and challenge of the Post Office and uncovered some of the problems where Sheck's UKGI did not. The creation in 2018 of the policy team within the core department has been a positive development, providing as it does a cadre of dedicated civil servants who work alongside UKGI to provide additional scrutiny and challenge to the Post Office. It is common ground then that this system necessarily depended on individuals acting in good faith, providing honest and truthful information up the chain. The evidence heard by the inquiry indicates that the Post Office and several of its senior people were, at best, recklessly indifferent to the truth and, at worst, culpably dishonest. Time and again, the Post Office provided materially false, misleading or incomplete information to government ministers, to Parliament, to the criminal courts and to the British public at large. And frequently, especially before mid-2018, the officials from Sheck's UKGI, whose job it was to scrutinise and challenge the Post Office at the tier above the board, identify and surface risks and provide impartial, objective and well-researched information and advice to ministers, appear to have done not much more than repeat what the Post Office told them. The evidence is well known to the inquiry, so I refer briefly to just a small handful of the many, many examples where ministers were provided with misleading or untruthful information. You'll remember Sir Ed Davey receiving a briefing from Sheck's officials based on information provided by the Post Office to Sheck's, which assured him that Horizon had proved robust, that there were no systematic integrity issues, that the unions had expressed confidence in Horizon, that there was proper training, that there were proper audit processes and no backdoors, that there had been regular reviews, there was an appeals process and legal representation, and that no court had ever found problems with Horizon. Much of that was, of course, untrue. Following Sir Ed Davies' meeting with Sir Alan Bates, he, Sir Ed, asked Sheck's officials for further information on each of the issues Sir Alan raised. In response, the Post Office gave Sheck's definitive but false assurances, including that Horizon is fully robust, that its integrity and sound basis have been demonstrated over many years, and that the JFSA's allegations were unsubstantiated. Each of those assurances would appear to bear the hallmarks, we suggest, of the Post Office's communications team. Sheck's passed these assurances on to the Minister and drafted a letter for him along the same lines. These assurances included untrue statements that there was no remote access and proper independent audit logs. Paula Venables gave Jo Swinson the explicit assurance in writing and to her face that the Post Office was compliant with its post-conviction duty of disclosure and that there was no reason to conclude any prosecutions were unsafe. There was no mention of the Clark advice. The assurance was false. Baroness Neville Rolfe was given a misleading summary of Second Sight's conclusions, and by Tim Parker, a misleading summary of the progress of the review he had commissioned at her instigation, and a misleading summary of Jonathan Swift KC's most damning findings. Nor did Tim Parker ever inform her or her ministerial successors that the continuing work he'd promised as part of his review had been shelved. More generally, ministers were never told about such crucial pieces of information as contained in, for example, Jason Coyne's expert report in the Julie Wolstenholme prosecution, the Helen Rose report, or the Clark advice, to name just a few examples. Ministers of different political stripes were vocally critical of some of the information and advice provided to them by officials in Checks and UKGI. Their evidence provided an unvarnished and candid insight into the inner workings of government. Jo Swinson was at times memorably apoplectic when, during her evidence, she was shown documents that she'd never seen or been given access to during her time as minister. Sir Ed Davey and Margot James were more restrained, but nevertheless clear, in their view that they were not given the sort of accurate, reasonably complete and balanced information that they were entitled to expect. While other ministers questioned and sought further information and assurances, Baroness Neville Rolfe was in the minority in having had doubts at the time about what she was being told. She said, "By this time, August 2015, I'd lost confidence in the quality of Shex's advice. We were going round in circles, and they were unwilling to engage with the issues in the way I felt they needed to. In my view, Shex had lost objectivity, and its officials were unable or unwilling to scrutinise Pol properly, even though that was an essential part of their role. The advice they gave seemed closed-minded, deaf to the issues, and constantly repeating the same mantra. As time went by, I felt as though they were trying to obstruct or shut down my efforts to get to grips with the issues." Ministers understand that one of their roles is to scrutinise and challenge, but the evidence demonstrates it's totally unrealistic to think that they can challenge more than a small fraction of the information and advice provided to them on a daily basis. Ministers' offices receive vast quantities of correspondence from other MPs, constituents and stakeholders, raising a wide variety of issues, concerns, complaints and requests for action, much of which would never be put before the minister themselves. The trickle of correspondence in relation to Horizon was a tiny proportion of the total. So ministers are necessarily, to a very large extent, reliant on officials to highlight the correspondence and other information they need to focus on. And the inevitable result of the consistently misleading information, partial advice and false assurances given to ministers by the Post Office via Shex and UKGI, essentially being told nothing to see here, was that these busy ministers by and large focused on the issues in other areas of their portfolio which were seemingly in greater need of their attention. All the ministers explained how their usual experience was that civil servants acted with appropriate objectivity. But the department agrees with UKGI that there were certainly occasions on which Shex UKGI advice to ministers was insufficiently objective. This is not the only public inquiry to reveal evidence of officials falling short of the expectation that they act in accordance with the Nolan Principles. We refer in our written closing statement to the infected blood inquiry and the Magnox inquiry, and there are other examples, perhaps most obviously Hillsborough. It's also obvious that the department's clear expectation that the Post Office would ensure that its staff too acted with candour and consistently with the Nolan Principles was misplaced. The government realises it needs to look again at how appropriately high standards of conduct are observed at its public corporations and other arm's-length bodies. It will be for the inquiry to identify the reasons why accurate and objective information was in such short supply. I will, in due course, offer some suggestions as to some of the causes, and the department would welcome suggestions that the inquiry has for improvements in the future. As you know, sir, the government has committed to putting forward legislation to introduce a new statutory duty of candour, backed up by criminal sanctions. That was one of the recommendations of Sir Brian Langstaff's infected blood inquiry report, in turn a development of one of the recommendations of Bishop James Jones's report into the Hillsborough disaster. The department presently sees no reason in principle why this duty of candour should not extend to public corporations like the Post Office and indeed across government. So what were the reasons why justifiable expectations of candour were frustrated in the course of this scandal? The starting point, as Alistair Cameron put it, the original sin, was, we suggest, the Post Office's institutional culture. It was a culture which seemingly tolerated indifference to the truth, and a culture, embodied in its postmaster contracts, which looked down on, mistrusted and exploited postmasters. The inquiry will form its own view of the executive and board level culture at the Post Office at relevant times. The evidence may suggest that it was, at least at some stages, weak, arrogant, unintelligent, defensive, incurious and closed-minded, with far too much emphasis on internal consensus, too little space for internal challenge, and firm resistance to any external scrutiny. We suggest in our written closing statement that this was an institution which was, at board and executive level, badly infected by groupthink. In our written closing statement, we discuss the causes and symptoms of groupthink and draw attention to the findings and recommendations of other recent public inquiries in this respect. It is regrettable, to say the least, that ministers were never informed of these profound cultural problems. Likewise, Joe Swinson was understandably aggrieved that the Post Office's boards and SHEC's officials shared concerns over Paula Venels's aptitude and performance as CEO were never drawn to her or any other minister's attention. I'll return to the theme of culture and cultural transformation in due course. A second theme is the extent to which SHEC's UKGI officials saw it as their role to scrutinise and challenge the Post Office. Clearly that was their role on behalf of the department, but it seems this was not always clearly understood and acted upon by all relevant officials. As a responsible and self-critical public body, UKGI has clearly reflected on the reasons why that may have been the case. The department agrees with UKGI's observations and adds only the following. First, we strongly agree that the starting point is that SHEC's UKGI officials were entitled to place substantial reliance on the information and assurances provided to it by the Post Office. As Sir Stephen Lovegrove observed, it's not SHEC's UKGI's role to challenge everything they're told. At the same time, clearly there was a need for SHEC's UKGI officials to review the available information and ensure that the advice and information they provided to ministers was clear as to its sources. As Baroness Neville Rolfe stated, if I had been my previous self as civil servant sitting in that seat, I would have gone away and I would have read the whole of the Second Sight report, and I would have gone through all of the negative findings, understanding what was right and what was wrong. That wasn't done. What they did was take advice from the Post Office because they felt the Post Office could give the answers, and that isn't what you do. As a good civil servant, you look at different sources. Second, the evidence indicates that the two-hatted role, as a NED on the one hand and as a shareholder representative on the board on the other, and as a shareholder representative on the other, may have led some SHEC's UKGI officials to perceive that there was a conflict as between their duties to the shareholder and their duties as a Companies Act director. It appears that this may have led to confusion as to the importance of independent scrutiny and challenge and the importance of providing independent, objective and impartial advice and information to ministers. The department notes that the IOD, the Institute of Directors, in its recent report concluded that at times the two-hatted role may have led to confusion and suggested that the parameters of the shareholder NED role should be reconsidered. Third, the inquiry heard evidence which may suggest that the confusion which flowed from this two-hatted role, if indeed it did flow from the two-hatted role, led the shareholder NED at times to increase susceptibility to the Post Office's own groupthink and acceptance of the Post Office's internal norms. For example, Joe Swinson suggested that Richard Callard had gone native, and Baroness Neville Rolfe suggested that the shareholder team led by Mr. Callard had lost objectivity. Fourth, many SHEC's UKGI staff do not, or at least did not, have classic civil service backgrounds. Given its highly specialist work, that's perfectly understandable. But the evidence may have tended to suggest that, as is hardly surprising, that may have meant the Nolan principles, as expressed in the Civil Service Code, were not always so deeply ingrained. This was a point made by Baroness Neville Rolfe. In addition, the early shareholder NEDs indicated that they were given almost no training in this inherently difficult role. The department therefore warmly welcomes the improvements that UKGI has made to its operations in the wake of this scandal, including, but certainly not limited to, improved recruitment and training, and embedding with greater force the importance of the Civil Service Code. The department is clear in its view that a centre of excellence for corporate governance within government remains essential. The department also recognises that had the department had its own post office policy team at the relevant times, this would have provided an additional mechanism to scrutinise and challenge the post office and thereby reduce the government's ministers' reliance on SHECs and UKGI. In our written closing submissions, we make the point that the management, governance and oversight structures that were in place did not exist in a vacuum. In the same way, the justified expectation of and entitlement to honest and truthful information and advice in accordance with the Nolan principles did not exist in a vacuum. They all form part of a broader legal, regulatory and indeed ethical ecosystem. That ecosystem includes not only the Financial Reporting Council Code and the Civil Service Code, but also the Companies Act, Employment and Disciplinary Law, the Criminal Law and the Criminal Justice System, and professional regulation, including, as relevant, the regulation of solicitors and barristers. In a healthy society, it also includes ordinary codes of morally acceptable behaviour. That ecosystem serves to drive high standards of behaviour and deter inappropriate behaviour. It cumulatively failed in those objectives here with catastrophic results. The question is why? One answer may be that the jeopardy for improper behaviour, breaches of professional codes, breaches of criminal law, was insufficiently serious. As I've mentioned, the government has committed to give sharper teeth to the Nolan principles through the new statutory duty of candour backed up by criminal sanctions. As the department described in its written closing statement, the role played by lawyers in this scandal was particularly deplorable. The regularity and seriousness of disclosure failings is astonishing, and ministers quite justifiably placed real weight on the assurances that the Post Office had always complied with its duties of disclosure to the criminal courts. And the evidence of the role played by lawyers in misusing and abusing the important principle of legal professional privilege to evade external scrutiny was eye-opening. But the inquiry has also seen evidence which may suggest that the Post Office leadership set a culture which was critical of lawyers who deigned to place their professional integrity above the interests of the business. You'll recall Paula Venables' extraordinary September 2013 note. The government has heard the submissions made by the Hudgell's core participant group concerning the regulation of lawyers and will welcome any recommendations that the inquiry has in that respect. I next turn to address relatively briefly the issue of redress. I start by restating the department's position that it has worked very hard and in good faith to ensure that full, fair and prompt redress is paid to the Post Office's victims. There's been no lack of effort, but the department realises that this has been too slow for many postmasters and their families, and it is acutely conscious that the list of those who've tragically passed away before receiving full and fair redress continues to grow. In its written closing statement, the department has set out its position on redress in some detail, and I won't repeat that now. Instead, I'll use my time to address some of the bigger themes that emerge from the evidence in relation to redress. The first is to pick up a point made by a number of witnesses and indeed by the National Audit Office in its Government Compensation Scheme's Lesson Learned report, published in July of this year. That is that there is presently no centre of expertise within government to provide guidance, expertise or a framework for public bodies seeking to set up a compensation scheme. This means that each new compensation scheme involves a newly reinvented wheel, or once a compensation scheme has been launched, rebuilding the plane whilst flying it, to paraphrase Sarah Mumby's evidence. The second point, related to that first point, is that it's easy in hindsight to criticise an incrementalist approach to compensation scheme design and delivery because, as Sarah Mumby described, there's a tendency to assume that it was possible to build a perfect scheme in the first place. As Sarah Mumby explained, the least bad option is often to get going and make changes later rather than attempting to design the perfect scheme to start with. There's an element here of the test and learn approach suggested by Pat McFadden. Of course, so much the better if the initial design, even if imperfect, were to benefit from expert input of the type proposed by the NAO. Third, the department has regularly, proactively and constructively engaged with the postmasters' representatives and has regularly made improvements to the schemes in line with their suggestions. It set up the Horizon Compensation Advisory Board, which has played a hugely important role. It involved the representatives of postmasters in the design of the group litigation order scheme and the Horizon Convictions Redress scheme from the outset. And it will continue with this process of engagement and incremental improvement in furtherance of those aims, full, fair and prompt, out of the glare of this inquiry. Fourth, while Sarah Mumby and Kemi Badenoch suggested a lack of creativity in the government's response, and we note the Hudgell core participant group refer to a business as usual approach, in their written closing statement. There has, in fact, at times been genuine innovation in the way the department and the government as a whole has approached redress. It acted to go behind the GLO settlement by creating the GLO compensation scheme and ultimately secured primary legislation to ensure the continuing power to pay. It found creative solutions to speed up redress, most obviously fixed sum offers, which were a novel and genuinely game-changing development. And it promoted the controversial and groundbreaking legislation resulting in the mass exoneration of postmasters convicted of Horizon offences. These were not small things, and they were not well-worn solutions. As a mark of its seriousness, the government has set aside funding of £1.8 billion, which the Treasury has publicly confirmed is not a limit, and it's so far paid out around £500 million in financial redress. These are big sums, and the department is proactively looking to identify gaps in the existing schemes. The government is pleased that Fujitsu has recognised that it must share the responsibility for meeting the costs of the scandal. The Horizon Compensation Advisory Board's paper on the future of redress goes further than the National Audit Office's report. As well as advocating an independent body to deliver redress, it proposes that that body should have a role in monitoring the behaviour of government organisations through looking at both unresolved complaints and management information. The government would welcome the inquiry's view on this point. The department recognises that there is still much work to be done. It realises that every day that postmasters and their families continue to wait for full and fair financial redress is a day too long. It will continue to work hard to make improvements to the schemes in the interests of ensuring full and fair compensation is paid as quickly as possible. It publishes regular progress reports. It's subject to ongoing select committee and other parliamentary scrutiny. For example, the Minister has just today made a further statement to Parliament, a written ministerial statement. The Department would, of course, be very happy to provide further updates to the inquiry for as long as you would find that helpful, sir. And it will welcome the inquiry's recommendations on how to improve the system by which government provides redress and compensation for the future. Finally, sir, I return to the critical matter of culture and cultural transformation at the Post Office. The evidence heard by the inquiry has indicated that the profound cultural problems at the Post Office have existed over decades. The department has recognised the need for a complete reset of the Post Office's culture and a rebalancing of its corporate mission. Together with UKGI and the Post Office Board, the department has taken real and material steps to improve the culture. An example is the innovation of Postmaster Neds. But cultural transformation of a large and complex organisation like the Post Office with such deep-rooted problems takes time. Whilst the department has seen signs that the culture is genuinely improving, serious problems have remained. Without attempting to provide an exhaustive list, this is clear from the YouGov evidence, the evidence of Saf Ismail and Elliot Jacobs, the evidence about the untouchables, the executive bonus metrics, the history of the Horizon replacement project, and the circumstances leading to and following the dismissal of Henry Staunton. Clearly, the Post Office has remained an institution under real stress. Changing the culture of a large and complex organisation like the Post Office is not easy, and there have been and will be choppy waters to be navigated. But there are reasons to be optimistic. The department has faith that under Nigel Railton's leadership as chair, the Post Office is heading in the right direction, and the department endorses and supports his efforts towards a renewed and rebalanced Post Office. He has set a new tone at the top of the organisation, giving a clear vision of a future Post Office with postmasters at its centre. He's also started implementing the recommendations of the Grant Thornton report in relation to board effectiveness. The inquiry has heard evidence that there has been a noticeable improvement in the working relationships at board level, more streamlined governance arrangements, and much better communication with government. And the government hopes and expects that the new statutory duty of candour will help to drive improved standards across the post office. Mr. Railton needs time, and he needs the support of the department. New appointments to the board will be crucial. The department, with UKGI's assistance, is making progress in appointing NEDs with experience in organisational design, public sector ownership and major IT projects. We note the IOD's recommendations in its recent policy paper and recognise that in relation both to the post office and to public corporations in general, the government needs to act with real intelligence when making board appointments. As the Minister Gareth Thomas and the Secretary of State Jonathan Reynolds explained in their evidence to the inquiry, the government wishes to facilitate a wide-ranging conversation about the future of the post office and its culture, which includes the perspectives of the public at large. It recognises that profound questions about the future model of the post office should not be kicked down the road any further. That is why the department has committed to publishing a green paper in the first half of next year, which will seek views on a range of different proposals for a future post office network. The department urges all those with an interest in a future in which the post office and its postmasters can flourish to respond to that consultation. In sum, the government does not accept that the post office is not worth saving. To the contrary, it is essential that the post office is able once again to take its proper role as a trusted and trustworthy institution at the centre of our national life. Sir, the department remains committed to learning from the Horizon scandal in the interests of preventing anything similar happening in future. It will continue to reflect on the evidence that has been heard throughout this inquiry, and it will look forward to receiving the inquiry's recommendations in due course.
Thank you, Mr. Chapman. At this point, in the area of South Wales from which I come and where I live, I'd say, well, there we are. Except it's not quite there we are, because there's a rather important next step. Before I get to the next step, can I pay my tribute to all those who have participated in, written and articulated the closing submissions that I have received. It goes without saying that I have already found them extremely helpful, and I will continue to do so. I'm grateful to you all. I would also like to thank again all the persons who have attended this inquiry and shown such interest in it. I would particularly like to thank those people who attend in person as opposed to remotely for their good humour, discipline, and ability to sit through evidence and submissions, which no doubt some of them found extremely difficult to hear and take in. So thank you all for your very disciplined and good behaviour. I thank my team often enough that it becomes almost part of every day in my life, but I've had great assistance from a great team. And so what remains is the question on all your lips. But when will he report? I can hardly say, I don't remember. But I will say, genuinely, I do not know. And so I make no promises other than I will report as quickly as I sensibly can once I am satisfied, and I'll need to be satisfied, of all my crucial conclusions. That is, without doubt, many months away, but I hope it's not much longer than that. And that's all you're getting from me by way of a prediction. So thank you all again, and now we will depart.